All right, great. Well, hello and welcome back to another edition of the Michigan Journal of International Law podcast. I'm Ryan Shaw, a current 3L and managing articles editor of the journal. I'm excited today to be joined by Professor Caroline Davidson of Willamette University School of Law. Professor Davidson is a leading scholar in the areas of international criminal law, international human rights law, and transitional justice, among other areas, and has worked in multiple countries before becoming a professor at Willamette, including some time in Brazil, Chile, Bosnia and Herzegovina, Colombia, and Canada. Additionally, Professor Davidson served as a prosecutor at the International Criminal Tribunal for the former Yugoslavia in The Hague, where she worked on two trial teams in cases involving the international crimes of genocide and crimes against humanity. So we're honored to be publishing her article in issue 2 of this year's journal titled The Gender of International Criminal Law. Professor Caroline Davidson, welcome to the MJIL podcast.
Thanks so much for having me.
Well, thank you for being here. And I want to start a little bit with your background and how you kind of started working in international criminal law before we talk more about your article. I think you have a really unique perspective in that you've worked both as a public defender in at the domestic level in Oregon and as an international prosecutor in The Hague. So I'm interested in knowing a little bit how you contrast and compare those two experiences. What what can a public defender in Oregon teach an ICTY prosecutor and vice versa?
Yeah, gosh, it is kind of, at least as an academic, it is cool to have those two different perspectives, particularly as someone who teaches criminal law and criminal procedure, and evidence for that matter. It's interesting to be able to draw on those experiences. But gosh, what can one teach the other? I mean, I think a lot of people at the tribunals, in fact, have significant domestic experience. So I don't know that I'm all that unique. It's just I may be unique in that I've come back, maybe, or not. I don't know. Nevertheless, I think one of the key takeaways is that the device that they use in international criminal law is a trial, and it's a criminal trial. And it comes with all of the usual issues that one needs to think about with a criminal trial, which is you've got people involved and you've got, human beings. And so, as a defense attorney, obviously you're very acquainted with the defendant and the particular challenges and concerns of that defendant. And I guess at the international level, they're dealing with much the same things, right? They've got issues of competency, they've got issues of, provisional release and whether or not people are detained pre-trial and whether or not they should be detained during trial. And um, I guess, yeah, one of the things is that while things are very different in some ways, the crimes that are being charged are very different and are obviously very serious crimes on the international level. The sort of the fundamental structure of the thing is in many ways very similar in that you're dealing with, human beings who are on trial and you've got to try them in accordance with human rights principles. And in the US, I think we tend to think of it more in terms of due process principles, but it's barking up the same tree. You've got to deal with all the challenges that trying a human being and in the international scene, often an elderly human being, all the challenges that that entails.
Yeah, and so the ICTY was one of the earlier international criminal tribunals that existed. I believe it was constituted in the early 90s, and you worked in the tribunal later in the 2000s. I'm
Mhm.
curious what your impression was going to The Hague at that time. The tribunal had been up and running. It had prosecuted
Mhm.
uh, military and civilian uh, perpetrators of international crimes for a while at that time. Do you think that the ICTY overall was a success? If you could give it that assessment, did it lay kind of future groundwork for other international tribunals like the ICC, which came along later, and other ad hoc tribunals that we've seen?
Yeah. So tough, a lot in that question. I think the ICTY was extremely successful in some ways, right? So I think it established some really important precedent on a variety of fronts, but including in sort of related to my article, I suppose, including on the gender-based crime front, right? There was novel precedent establishing rape as torture, rape as a crime against humanity, rape as sexual enslavement. So the ICTY helped chart a path for, as along with the ICTR for that matter, for, negotiators of the Rome Statute. And to be fair, some of this was happening contemporaneously. So the Rome Statute was being negotiated at the same time as these early ICTY cases were happening. But at least it helped establish a lot of really important precedent. I guess so from that perspective, I think it was quite successful. And I'd also add that the ICTY was actually quite successful in prosecuting quite a number of people for gender-based crimes, among, again, a host of other things, genocide and um, other serious crimes. The one sort of caveat I would say is it depends on what aim you're looking at it from. If you're looking at it through the lens of peace and reconciliation and through the lens of have people in the region sort of do people in the region view it as a legitimate institution? At least and this is not based on my experience there in the recent past. This is really just based on reporting that I've read. I think there's reason to be concerned that it was not entire as successful as it might have been on that front, right? That there's a lot of denialism still in Serbia. The point at which you've got people who've served their sentences for war crimes, crimes against humanity, and are heading back home to Serbia and being celebrated as heroes, right? That's obviously not the message that the IC2Y was seeking to send. So again, I think it was very successful on some fronts and less successful on others, and perhaps ultimately shows the unsurprising point that a tribunal can't achieve everything, right? That we may be placing unrealistic expectations on tribunals when you're serving a lot of different purposes. Some may be more realistic than others.
Yeah, absolutely. And I think, you know, what you highlight in the divide and kind of the reception of the legitimacy of international courts, kind of brings to mind that there's really there's kind of a cultural and communication element that exists in these tribunals as well. Um, Now you speak multiple languages and you worked in multiple countries. I wonder if you could talk about kind of the importance of language when you're interacting with, let's say, criminal defense or defense attorneys
Mm.
that are from other places. You're an American, but you've worked all over, and you're working within the context of acts that were committed in the former Yugoslavia.
Mm.
What importance does language have, and would you recommend to someone interested in international law, like go out and learn as many languages as they can?
Oh, for sure. I would always recommend that to everyone. But that's partly just because I think languages are great fun, and I think it's such a wonderful way to connect with people. To try to speak their language. So, at any rate, I think that's always a worthwhile endeavor, whether or not you're practicing law and whether or not you're practicing international law. But as to the sort of relationship between languages and law, and I guess my practice at the Yugoslavia Tribunal, it is true that it was useful, and particularly the languages that were relevant for me at the Yugoslavia Tribunal were French and English. And I guess Spanish, just because I had a Spanish teammate, so it was easier to speak with him in Spanish. Um, but at the Yugoslavia Tribunal, you had some trial chambers that were French speaking and some trial chambers that were English speaking. And realistically, they may have native languages that were something completely different, but the language in which they were working was French or English. So, at least on one of the cases that I worked on, we had a French speaking trial chamber that would issue decisions that we would then I, as the little writer bee, would have to respond in English because my senior trial attorneys were American. So, anyway, there's an interesting dynamic there where, although I wasn't writing in French, I was reading the decision in French and then responding in English. And that was typical, right? That was very common where people are working in languages that are often not their own. Um, and I think that's really candidly the much more commendable thing is people who are writing or appearing in court in a language that is not their own. I think that is um, really quite it's something we underestimate how challenging that can be for people. At any rate, so I think it is very helpful to have more languages in your toolbox at an international environment like that, whether you're using it in the actual work before the court or whether you're just using it to speak with your teammates. With Spanish, I mean, so my work in Chile and Colombia is was really more my research, right? So I'm interviewing people. I wasn't litigating there, but I really don't see how I would have been able to talk to a lot of those people if I hadn't spoken Spanish. And so it was so enormously interesting to learn about the work that they're doing, which is really incredible work. Um, and it would be much more difficult to do that kind of research without language skills. So again, I'm always going to push learning other languages on people because I just think it's a worthwhile endeavor.
Well, let's shift a little bit into the article that MJIL is publishing
Sure.
in the next hopefully couple of weeks. Um, so, what are the main feminist critiques generally of international law, and where do you kind of pick up on them in this article in the criminal context? Where do you argue that reform is needed, and where is it possible? How can it be achieved?
Yeah, so I attempt in the article to do a bit of an overview of various feminist critiques, and I think you really have feminist critiques that are going in very differing directions. So I guess one of the difficulties is, of course, if you pick one reform, it might please one group of feminists and not another. So just note I think they're barking up somewhat different trees. And I identify as a feminist straddler. Like I think there's a lot of merit in the arguments from different camps of feminists. So at any rate, the chief critiques that I identify are, I think, what would likely be called the liberal critique. That's, I think, probably an earlier critique of international law generally, but has also been applied in international criminal law. And the critique is that the law is focusing on men and is not sort of treating women as full subjects of the law. And Hillary Charlesworth and Christine Chinkin made this argument decades ago in their book, and I spent a lot of time canvassing their arguments in the article. Um, there's sort of the radical feminist critique, which I think in this context winds up making a somewhat similar argument that these sort of structures of dominance are such that the law is ignoring harms to women, and is I think in general, radical feminists are concerned about sexual violence as being sort of part of this structure of dominance. And um, at any rate, and so this concern that the law is insufficiently attentive to things like sexual violence and other harms against women. From there, I think there's a feminist critique that cuts in a very different direction, which is the anti-colonial feminist critique. This is Karen Engel and Vasuki Nisaya and Diane Otto have written on the, and others, right, have written from this lens, and they are much more suspicious of this feminist push for more criminal law particularly in the international sphere, right? But probably in general. So there's, I think, a significant overlap between the decolonial or anti-colonial feminist critique and an abolitionist critique, right? Even though they don't necessarily always explicitly invoke abolitionism, though Engel does in places. At any rate, that is pushing in a very different direction, where they're saying, look, there's a particular brand of feminism that has prevailed in international criminal law, and that's not our brand, effectively, and that it is doing so to the exclusion of other versions of feminism that would likely be much more open to sort of restorative justice mechanisms, and local mechanisms and all that kind of stuff. So again, those are, I think, differing critiques, and I think all of them make good points. So I think they all make good points. And I sort of try to point out ways in which these critiques um, potentially play out in international criminal law in the piece.
So your article kind of hones in on I would say like two broad areas in which international criminal law makes it difficult to bring prosecutions against gender-based crimes. The first one is that oftentimes, or almost always in international criminal law, there's a requirement that there's some nexus of the crime to an armed conflict. And then the second one is kind of who do we choose to prosecute in
Mm.
international criminal law? Almost all of the time, and you can even go back to maybe Nuremberg on this point, we're looking to prosecute the highest possible levels, which is, maybe not unlike what prosecutors in the domestic context do. If you're trying to prosecute a
Sure.
mafia ring, you're trying to
Yeah.
get people to testify against each other and work their way up
Hmm.
the chain. But where does that kind of leave us if we're narrowing the scope of international criminal law to the top commanders in an armed conflict? What are we leaving out, and why is that disadvantageous to someone who's taking the feminist perspective on how or at least your
One of
feminist
these coming.
perspective, one of them on how
Right.
international criminal law
Yeah.
should be done?
Right. No, fair. One thing I would say is in so on the sort of what I call the war fetish in the piece, to be clear, it is not technically a requirement for a nexus to war, at least for crimes against humanity, right? Crimes against humanity requires no connection to armed conflict now. But what I point out in the piece is that, in fact, right, the cases that are being litigated in these international criminal tribunals, and in fact, often in domestic contexts as well, and in the hybrid internationalized context, in fact, what is being prosecuted almost without exception are crimes that are associated with armed conflict. And so I'm sort of pointing out here that by retaining, even though it's not a legal requirement, this armed conflict focus, we are ignoring a lot of gendered violence that actually, for which international criminal law potentially could be a useful tool. And there, I think I reveal my stripes where I'm not entirely, even though I think they make a lot of good points, an anti-colonial or abolitionist, I suppose I'm anti-colonial, but I'm not an abolitionist feminist, probably. Though I'm sympathetic to that argument. Um, I think here I reveal if I'm thinking of using international criminal law as a tool, sort of that would suggest that I'm not an abolitionist, right? At any rate, I think so. On that war piece, I just want to clarify it's not actually required. It's just, in fact, almost all of these cases have a connection to armed conflict, and where they don't, they fall apart. And it may be that they fall apart for completely different reasons, not because there's no armed conflict, but I'm just noting that there are very, very few examples of cases involving international crimes outside of the context of armed conflict. Um, okay, so that's one point I make in the piece. The other one is this focus on those most responsible. I think you're quite right. There are a lot of good reasons why an international tribunal might want to focus on those most responsible, right? There are retributive reasons. They've caused the most harm, right? And often those most responsible are going to be senior people, though that's not required, right? There are deterrence reasons, utilitarian reasons, right? We want to deter other commanders in other places who likewise have the capacity to do a great deal of harm because they're in a position of guiding the behavior of a lot of people. Um, there are potentially expressive reasons. I mean, there are a whole host of reasons why we might want to focus on more senior people, but I think it is an underexplored problem for prosecuting gender-based crimes. It has been shown again and again and again at the ICC and in other places that it is challenging to get to the high level commander. Now, some of that may be doctrines that the court in the ICC in the Bemba case, for example, has been very heavily criticized for its reworking of command responsibility doctrine in a way that was viewed to shield Bemba from responsibility inappropriately in the view of many commentators. Um, so some of this may be coming from difficult, the ICC has made it ever more difficult to prosecute high-level commanders at the same time as the prosecutor has announced this focus on those most responsible. So I effectively advocate in the piece a flexible conception of those most responsible. And almost more importantly than that, because I think the ICC is already largely using that, thankfully, um, is that domestic jurisdictions should not blindly copy the ICC's focus on those most responsible. And I suppose the ICC, as part of its complementarity analysis, should not necessarily demand that domestic jurisdictions copy a focus on those most responsible. There may be non-justice impeding, like there may be valid reasons why a domestic jurisdiction is aiming for a lower level perpetrator, um, because they can't prove the responsibility of the high level perpetrator. And so if there is a tension between going after those most responsible and this prioritization of accountability for gender-based crimes. And I think we need to acknowledge that, which isn't to say that prosecutors shouldn't try to link higher level commanders to those crimes. I think they should, but there is, I think, a tension there that I try to point out in the piece. And then that is made even more difficult by the ICC's interpretation of Article 25, which is much more demanding than the doctrines that we had at the ICTY. At the ICTY, we had joint criminal enterprise, and there's a big fight about that, whether that's good, whether that's bad. I think um, there are some valid concerns about that doctrine. In my view, most importantly, the potential to hold lower level offenders accountable for stuff that happened, you know, like in a totally different part of the country and that they had nothing to do with. So I think there are some potential unfairness concerns related to joint criminal enterprise. But in particular, JCE 3 captured, in my view, appropriately, conduct that would not be captured under the ICC's tests as a function of mens rea and as a function of their focus on control of the crime through a variety of different doctrines that they've come up with for Article 25.
So you mentioned domestic courts and complement the principle of complementarity that's applied
Mhm.
by the ICC and other international tribunals. So I'm curious about your research, especially in Latin America, when it comes to domestic courts prosecuting what has generally, well, sometimes former military dictatorship in the case of Colombia, against, guerrilla groups like FARC. Um, have we seen domestic courts, whether in Latin America or elsewhere, kind of fill that gap that you identify in terms of being able to have more success prosecuting gender-based crimes? Um, and do you think that, in some sense they're able to kind of fulfill that purpose in a way that's easier, maybe not politically, but
Yeah.
mechanically? I'll just say I had the chance to recently watch the movie Argentina 1985, which is
Mhm.
about the trial of juntas. And it was in that context, it was the mothers and grandmothers of the disappeared, oftentimes bringing these stories to light about oftentimes what were gender-based crimes, and
Mhm.
the story of that is kind of bumpy. There were prosecutions and then there was pardons, but then prosecutions continued. So I'm
Mhm.
just curious to get your take on that.
Yeah, so whether domestic jurisdictions can pick up the slack in a way, so I think the answer is yes and no. I think the same challenges exist on the domestic level, or similar challenges exist on the domestic level. And I would say the two jurisdictions I'm most familiar with are Chile and Colombia. And I would say those are very, very different um, systems are what's going on there is very, very different. So in Chile, you've got prosecutions for crimes that occurred right in somewhere between what 73 and 89, so quite some time ago. And they are being brought on a victim by victim basis. They're sort of much more akin to a an ordinary domestic criminal case in the sense of the scale of the cases mostly. Now, there are some exceptions to this, but these are not mostly really large trials. There are a lot of little trials. So you could have a particular defendant who's been convicted in a bunch of different cases. So on the one hand, and there are pros and cons to that, right? But I suppose one pro of it is actually you do have victims bringing cases for the things that happen to them, and victims bringing cases, that's sort of a complicated. There's a government office that assists with this, and for a long time it was private complainants. They have the ability to file private complaints that start a criminal case. So that, again, it's a very, very different model, but one where you are at least potentially drilling into the facts of individual cases um, and you potentially have the benefit of being able to bring attention to all the crimes that may have come to a victim. Now, with the caveat that the Chileans are proceeding under the domestic criminal code at the time, and so they're not being labeled international crimes, even though the discussion of international crimes is very much in the backdrop of the cases, because that's what gets them around the statute of limitations and the amnesty. In Colombia, it is very, very, very different model. There were cases that were going through the ordinary judicial system for international crimes, effectively. But there are a couple of different special transitional justice mechanisms in Colombia. Um, there's the Justice and Peace, which is happening in the court system, but is specific to, it's mostly dealing with paramilitaries. And then there's the Special Jurisdiction for Peace, which is its own institution. And it is part of the 2016 Peace Accord. And it, like the ICC, has a focus on those most responsible. So, again, they, I think, are struggling with very much the same difficulties as the ICC in this sort of linking gender-based crimes to higher level. They're not called defendants there, they're called comparecientes, so people who appear before the special jurisdiction for peace. So very, very different models, and I think there are pros and cons to each model, and both systems, I think, are really doing incredible work to try to bring attention to these crimes, but there are challenges in both models.
So, what and your proposed kind of solution in the article is a conception of feminist judging, feminist prosecuting, and theorizing. So
Yeah.
I'm curious, what does feminist prosecution look like effectively in the current ICL framework? And do you think that this will be kind of where the real reform work happens, or is it going to be, in this case, more in the scholarship, in the feminist theorizing space, and kind of pushing these conceptions forward to make reform in terms of how we conceptualize ICL.
Ryan, you're very sweet to think that we scholars make a difference. I love that you
I
think
do.
there's a chance that we're making a difference over here. Anyway, sorry, jokes aside, first of all, I want to be clear on what I mean by feminist because I put it in quotes in
Yeah.
the article, and there's a reason I do that, right? I don't mean like convict at all cost, feminist judging, prosecuting, and scholarship, right? The scholars don't have the power to convict anyone anyway. But what I mean by that is seeking justice with an awareness to context. And I sort of borrow a definition from Diane Otto on this, where um, sort of obviously, in light of the human rights and due process constraints that are inherent in a criminal trial, nevertheless, being aware of the context of these decisions and the implications of these decisions. So anyway, the feminist is maybe not as scary as it sounds. At any rate, I do think that there's a role for prosecutors and judges in this. I think one of the things is prosecutors one of the things I point out in the piece is I think prosecutors can be attentive to scenarios of gender-based crimes outside of armed conflict, and frankly, just atrocities outside of armed conflict. Bring and so um, I think there is utility in trying to disassociate crimes against humanity from armed conflict, even though technically it's not a requirement that they be connected. We still mostly see it litigated in that context. And so, at least I think it is worthwhile for prosecutors to be thinking through and trying to bring cases, which, to be fair, I think at the ICC they are trying to do, um, that are not in the context of armed conflict, because otherwise we are sort of unnecessarily limiting a field of law, which again, if you're an abolitionist, you're okay with because you don't think it should exist at all. But if you think that there's utility in this endeavor, we still seem to have these blinders on where we only see crimes against humanity or at least we only litigate crimes against humanity in the context of armed conflict. So one thing is kind of being attentive to crimes against humanity outside of the context of armed conflict. Um, Another thing I think prosecutors can do is in interactions with domestic jurisdiction, which to my knowledge, I think there are quite a few, right? I think the prosecutor understands that one of their very important roles is supporting domestic efforts at accountability. And there, I think the prosecutors can be helpful by being really transparent about where some of the ICC's constraints don't constrain domestic actors, um, and seeking to assist domestic actors in these prosecutions or in something like the special jurisdiction for peace, where it's not exactly a conventional prosecution, it's a little different, but in their domestic accountability efforts. So I think that is a fruitful area of engagement for prosecutors. Judges as well. I mean, one of the things that, in the piece I do, and this may be tilting at windmills, I I I joined the chorus of voices that is a little skeptical of the ICC's reworking of Article 25. And that may be a lost cause, right? It may simply be that, I mean, they're not bound by precedent, even their own. So who knows? Maybe things can turn around. But I think there is some narrow little room, even within the interpretations of Article 25 that the court has crafted. Um, but I think that judges should continue to be, or should be, aware of where doctrines that they are creating are boxing themselves in, and unnecessarily, right? Not in ways that are demanded by the statute. Um, and then again, on complementarity decisions, again, I think the judges as well have a role here in potentially understanding that domestic jurisdictions may be pursuing lower level perpetrators. In some instances, they may be doing so to distract and to not seek justice in a meaningful way, et cetera. But in some instances, it may be for justice seeking reasons that are worthwhile. But of course, I think that, of course, I think there's a role for scholars and activists as well. We matter too. No, I mean, I think that there's still important work to be done. I think a lot of the change on this front, a lot of the positive changes of the 90s, where, at least in my view, positive changes of the 90s, where there was increased attention to the issue of gender-based crimes. And we almost take it for granted now, but it was not something that could be taken for granted at the time, right? Is the result of important work from activists and scholars who were pushing for attention to these crimes. And so I don't want to give the false impression that I'm suggesting international criminal law has been a failure on this front. I don't think it has. I think it's had some tremendous successes. I'm merely pointing out that while we're fighting about kind of the meaning of subcrimes within crimes against humanity, like gender persecution or forced marriage, there's been a lot of discussion about what these subcrimes mean. And I think that's useful and important discussion. I think we also need to be aware of some of these structures that we kind of overlook and take for granted that are making it incredibly difficult to prosecute people for these crimes. Um, and that was kind of that's what I was trying to achieve in the piece.
Yeah, and for what it's worth, I actually do think that scholarship probably plays an outsized role in international law, vis-a-vis domestic law, just because, it's about it can have an impact on shaping custom and practice, and oftentimes international law is still looking for answers in certain areas and still being formed, and in some ways is more malleable than at the domestic level. So I do think there's a large role for the theorizing, but
I like it.
that's just me.
I'm going to tell my colleagues that I matter more than they do because I'm an international law scholar. I'm going to pretend someone's listening. I like it.
Well, just two quick wrap-up questions that we're doing with all of our authors. So, if you could recommend one piece of media on international law, whether it be a book, article, or movie or TV show, what would it be and why?
Yeah, I am going with a classic. I still think Samantha Power's A Problem from Hell, what is it? A Problem from Hell, America in the Age of Genocide is a tremendous book. Yeah, I mean, she achieves what I think is an almost unachievable feat of making a book about genocide very readable. And so obviously it's an extremely serious topic, but I think just such a great explanation and indictment of the US's role in genocides over the years. At any rate, I still recommend it, and in fact, was thinking I need to reread it. I need to bring it home from school and reread it. But yeah, that would be my book recommendation.
Great. Final question. What would be your advice for a law student who wants to publish a sharp original work of legal scholarship?
I think my first piece of advice would be, and this is maybe to all of us, right? Not just law students, but why are you wanting to write a law review article? And I would consider, could you have as much or greater impact writing some or producing something else? So for you, kudos to you. You've pivoted and done a podcast. I think that is a cool, at least in the realm of international law journals or law journals in general, an innovative idea. Um, but assuming you're committed to the process of a law review article, I guess I would think about what you see in the world that you think looks wrong, right? What offends you about how things are working currently? And some of this, of course, in international law, it's um such a strange field of law, and it's not something that all law students have a lot of access to. But I would, regardless of the area of law, I guess, read up a lot. So because I think sometimes we expect to walk into a project with a thesis already ready to roll, right? And sometimes it takes quite a lot of reading to get acquainted with how a particular either legal system or rule or whatever it is works. So the reality is, I think one has to do quite a bit of reading to get to a place where you've got sort of a tentative thesis. And so I'd say kind of figure out a topic or an issue that interests you, read a lot about that, make an outline, and then start with your tentative thesis and accept that as you learn more, your thesis might change, and then rework accordingly. Um, and then I think I can't remember the author. She's I'm just blinking on her name, but bird by bird, right from there, just section by section, right? I think the blank page is daunting, and so go filling it in bit by bit, and get feedback from fellow students and obviously faculty that's at your disposal. Get people's feedback to try to get as many brains on the issue as possible. That's something I'm guilty of doing too little of. I don't want to bother my colleagues, but I should because things are always improved by another set of eyes. Um, yeah, I think those are the main things. I think the main thing is I think one has to start with quite a bit of reading to get acquainted with the contours of a problem, and then from there, bit by bit, plug away at the thing.
Sound advice. Well, Professor Caroline Davidson, thank you so much for joining the MJIL podcast. It's been a pleasure speaking with you today, and we hope that all of you will tune in for future episodes.
My pleasure. Take care. Thank you.
All right. All right. I will go ahead and stop the recording.